on in the gun world, but also how we're going to fix it together. And the content that I'm about to show you is FPC going on a freaking just a rampage through the gun controllers. We got some sugar, we got some salt, it's sour. There's lots of stuff that we're going to talk about right now, but we're going to start off with the Minnesota ban getting stuffed in the face of 18, 19, and 20-year-olds. Yeah, that's a good one. And then we're going to go with some interesting things that are coming out of the Fourth Circuit with Maryland. This is an FPC special. Everything will be linked in the description box below. I can't wait to hear what you guys think. And of course, make sure you hit that like button, subscribe to the channel, turn the notification bell on, and we are going to start off with the sweet because I love you guys. I want to make sure that you get that goodness. All right, check this out. This I love to see. The Eighth Circuit denied the government's appeal to hear our Worth v. Jacobson, Minnesota age-based carry ban lawsuit in banc or full court. This leaves the three-judge panel's decision striking down the ban in place. The only place for Wall's cronies to go now is the Supreme Court. This is a really big deal, guys, because they were going to want to take it to a big court and then basically strike it down with different accounts of judges, et cetera, et cetera, et cetera, thus prolonging the event into the SCOTUS. However, in this case right here, they declined to actually take it up in the full court or en banc, as they said right here. Okay? What that means is the existing ruling prior stands, which means it's unconstitutional to block 18, 19, and 20-year-olds from carrying firearms just because they're 18, 19, and 20-year-olds. That's a big deal because if they decline to do that, the only other place that they can go is the SCOTUS. That's what he's saying. In fact, look at what the actual statement is from FPC, because this is Tim Walz. This is Tim Walz country, okay? Worth v. Jacobson, Minnesota age-based carry ban lawsuit. This order marks the latest in Minnesota's unbroken series of losses in our case against this unconstitutional carry ban. Perhaps Governor Tim Walz and Attorney General Keith Ellison should focus on complying with the Constitution rather than playing politics, FPC President Brandon Combs. Now, this is important because that second guy he just mentioned, Attorney General Keith Ellison, that's the exact same guy who we covered earlier this week when he was saying that he was going to go after Kia and Hyundai because cars were too easy to steal because they were being stolen. Just to put it in frame of reference. Now, that's the sweet part because now you've got a lot of other states that are doing the same thing, 18, 19, and 20-year-olds. All these pieces of just under 21 having no rights because of their age are going away slowly. Now, let's go to the salt here, because this is an interesting one, all right? So again, FPC, this is a tweet that they just put out, and I'm going to read you these documents, but effectively, they're upset that Maryland upheld the handgun purchasing license scheme, okay? Listen to this. The en banc Fourth Circuit has upheld Maryland's handgun purchase license scheme, with multiple concurrences saying the judgment was correct, but the analysis was totally wrong. Now, I'm going to read you the actual documentation and then what they're saying on the back end, because this is the important piece. Let me scoot it up a little bit for you guys because it's not showing all the way. Hold, please. Here we go. Since the Supreme Court issued Bruin, courts across the country have struggled to answer the many questions resulting from the court's new analytical framework. But this uncertainty does not extend to shall issue licensing laws, which the Supreme Court has indicated should not be cast aside in rote fashion by relying on Bruin's invalidation of may issue licensing laws. Now again, remember, may issue meant, I might give you your rights. Shall issue meant, I'm going to give them to you, it just depends how long we get there. That was the main difference, okay? We are not free to ignore the Supreme Court's clear guidance on the presumptive constitutionality of shall-issue licensing regimes, nor to unduly constrain legislatures seeking to employ such measures to prevent handgun misuse and violent criminal activity. So, in line with the Court's shall-issue discussion, governments may continue to enforce shall-issue firearms licensing regulations that impose non-abusive, objective requirements like background checks and firearm safety trainings. Again, this is licensure to own, okay? And because the plaintiffs in this case have failed to rebut the presumptive constitutionality of shall issue HQL statute, we reject their facial constitutional challenge and we affirm the district court's judgment. Affirmed. Okay, this is the part, that's kind of the backstory. But now let me zoom into what they said on the follow-up from another judge, because this is the part that's key and crucial. Remember in what I just showed you in the Minnesota carry ban lawsuit, they denied the en banc. In this one, they went en banc. So this is what happens and how they try to do this. Listen to this. Judge Niemeyer, the majority's new test is thus illogical. requiring plaintiffs to establish infringement before infringement can logically be determined. Okay? That is a key statement. I'm going to read you these in a second, but think about that. The majority's new test is thus illogical, requiring plaintiffs to establish infringement before infringement can logically be determined. Does that sound familiar? They did the exact same thing in California, in San Jose, from the whole mandated gun owners insurance. They said, well, we're not actually a requirement, it's not in place, so it can't be an infringement. It's exactly what their move has been. Now, let me read you these opinions, because this stuff is deep. The majority opinion should have ended with that analysis. Instead, for a reason I have difficulty fathoming, the majority opinion launches into illogical dicta to alter Bruin's clear test for applying the Second Amendment by requiring a plaintiff as part of Step 1 to demonstrate that the regulation infringes on the Second Amendment right. Specifically, the opinion states that under the first step of the Bruin framework, a court must consider the text of the Second Amendment and that among other plain text requirements, a regulation falls within the ambit of the Second Amendment only if the regulation infringes the Second Amendment right to keep and bear arms. Gratuitously applying the test to Maryland licensing regime, the opinion then concludes. Now, this is how they concluded it, right? The plaintiffs have not met their burden to show that the Maryland licensing law infringes the Second Amendment right to keep and bear arms. We therefore reject their facial constitutional challenge as Step 1 of the Bruin framework. All right, now listen to the follow-up, because this is the key point right here. Thus, the majority now makes infringement part of the showing that must be made at Step 1. Doing so, however, sets the Bruin test on its head, because this is all about Bruin and circumventing Bruin. Rather than requiring the plaintiff to prove infringement at Step 1, as the majority does, Bruin requires the plaintiff to show only that his or her conduct is covered by the amendment's plain text. The Second Amendment shall not be infringed, right of the people keep and bear arms, you know, that whole thing. Moreover, in addition to flipping the burden of the Bruin test on its head, the majority's newly created test is also circular and begs the question. Under it, the plaintiff must prove that the regulation infringes before the government is required to demonstrate the permissibility of the regulation by reference to historical tradition. Yet, Bruin makes clear that it is only after both steps are taken that infringement can be found. This new test is plainly wrong. Understand what they're doing. They're trying to create a new way to interpret Bruin that satisfies the Bruin decision without satisfying the Bruin decision. Okay? Now, this last one. This one's fascinating. By instead requiring plaintiffs bringing a Second Amendment claim to demonstrate at Step 1 the ultimate issue of whether the challenge law infringes the Second Amendment right, the majority fails to recognize that such a conclusion can only be reached after Step 2. And that's what the dissent has said multiple times in what I've just showed you. This is all about them basically saying, yeah, I mean, sure, it could infringe, but since it's not actually infringing now, it's not an actual infringement, so therefore nothing's done, nothing's wrong, so the Bruin test is satisfied in a circular logic, which does not make any sense whatsoever. The reason that these two things are so key next to each other, this is what Maryland did when they were trying to get a gun ruling with the full court of the en banc. Minnesota, which I showed you prior, didn't do en banc. It was denied. So the only step that they have is to move it forward to the SCOTUS, if they even push it that far, because they know they're unconstitutional. Guys, there is so much happening in the judiciary right now, so many lawsuits. Make sure you have that subscription turned on. Make sure that notification bell is on, and I will see you on the next one.